Welcome to Counsel Culture, the Business of Law podcast brought to you by Byfield. Welcome to another very special episode of Counsel Culture by Byfield. We are delighted to be discussing a newly launched report by the Institute of Business Ethics Task Force on Business Ethics and the Legal Profession. The IBE is a charity set up in 1986 to help organisations act with honesty and integrity. It's fantastic to welcome my guest, Guy Beringer. Guy Beringer, KC, is former senior partner of Allen Overy and Chair of Task Force on Business Ethics and the Legal Profession. Guy, it is an absolute pleasure to have you here today.
Lovely to be with you.
We are also joined by Gus Sellitto, founder of Byfield. Gus, how are you today?
I'm very good, Olivia, and I'm delighted we have Guy on the podcast talking about this new report, which we'll get into it, raises some really important issues about ethics in the profession and the reputation of the legal profession. So welcome, Guy.
Fantastic. So I think to begin, Guy, how did this report come up and why is it needed?
Well, the focus of the report is client acceptance and kleptocracy, although, as you said, it moves into some much broader issues of ethics relating to the legal profession. And it arose at the time of the Russian invasion of Ukraine, which, although it seems a long time ago now, it followed quite a long period where government policy was that actually we traded with Russia, we had links with Russia, and communication was a good thing. That, of course, all changed very dramatically and almost overnight. And government policy reversed. It left a lot of law firms, big commercial law firms, and indeed a lot of other businesses fairly high and dry because they had businesses and operations in Russia, mainly in Moscow, most of them, and had a number of Russian clients. And of course, government policy could change overnight, but it was rather more difficult for firms to extricate themselves from those engagements and from their presence in Moscow quickly. That resulted in a degree of criticism of them, which one might say was some of which was ill-founded, but that brought really very much into the sort of public view this issue of, well, what are the rules governing who you do act for? Who should you act for? More to the point, who should you not act for? And of course, that caused a little bit of difficulty because it transpired that the profession probably wasn't entirely clear about what those rules were.
Now, the report goes into, obviously, kleptocracy, state capture and corruption. Can you please define those a little bit more for us?
Yes, I mean, we'll start with, by the way, it tends to talk about grand corruption. I should say,
yes.
There's nothing grand about corruption. Basically, grand corruption is not much different from good old-fashioned ordinary corruption, but it's a term that the academics use, grand corruption, I think really meaning elevated to a state scale rather than individuals. The starting point is state capture, which is when the various organs of the state and the things in a constitutional democracy which exert checks and balances, which could be the judiciary, the court system, it could be the police, it could be educators, it could be a whole range of elements within society which actually check the behavior of the executive, where the executive, the government, therefore has effectively captured all those institutions and they simply do what it says. They do not exercise any form of independent oversight and break of what they do. That is what is known as state capture. And I mean, that's what the words say. And of course, what that tends to lead to is kleptocracy, where the ruling elite, so with state capture, you will have a ruling elite, which may be family-based, it may be party-based, political party-based, and it's where they exercise their power essentially to remove assets of the state into their own control and ownership, which is kleptocracy. It has, which will be relevant in a moment, a number of when you think about fairly obvious consequences, but these are perhaps sometimes overlooked by those who critics of the legal profession. Most of our rules and laws relating to money laundering and the controls over what you should do actually require that in the mix of things you're looking at to be some form of criminal offence. It may be something which is not necessarily a criminal offence in the place in which it's done, but would be here. Now, the point about state capture is you don't get that frequently, because what happens is people use what are in a normal constitutional democracy absolutely usual forms of commercial instrument, like licensing, like privatization, like joint ventures, like public-private partnerships. In a normal state with checks and balances, those are all perfectly proper instruments to use. Where you've got state capture, you actually use those instruments. But of course, a significant part of the population is shut out of those, but there isn't a criminal offence. So it's very hard for the actual black letter laws to sort of find anything to grip onto there. The other important point, which again is sort of relatively obvious, is that where you get state capture, you don't get evidence. So if you're going to say, look, show me, you say I stole this, well, I just participated in this privatization. There won't be any evidence. So that's why we'll come to later. We felt actually, that there had to be rather more steps taken by the profession to demonstrate that it was behaving properly.
Guy, this is a significant undertaking, and the report is quite comprehensive in the ground it covers. How big of a problem is this within the legal profession? Some of the issues that the report raises, specifically in those areas of kleptocracy, corruption, and state capture.
Well, that, as they say, is a very good question, because nobody knows the answer exactly, and many firms will protest and say, well, look, they would never handle business which might be viewed as problematic in terms of the sort of analysis of kleptocracy. When you go to civil society, and one of the things about our task force, which was unusual and potentially slightly challenging, was that we actually had people there from civil society. We had sort of gnarled old city professionals like me. We had academics like Professor Stephen Mason. We had people with a broader range of experience, and we had somebody, Patricia Robertson from the bar, just given because we were only looking at the solicitor's profession. So we had this whole range of views, and what became obvious when at the beginning somebody put exactly that question. Well, what's the scale of the problem here? Because we must be able to quantify. The answer to that lay in various academic pieces of work, which said, and because of the nature of the problem, these are estimates, but there is an academic consensus that there are huge amounts, there are trillions of whatever currency denomination you wish to choose, flowing into financial centers around the world, which are in very broad terms dirty money, and they're not stopped. Now, if you extrapolate from that, well, they must be getting in there somehow, and they must be coming via various channels, which are either don't know that their provenance is problematic, or in some instances don't care. And of course, that could be spread across. It could be accountants, bankers, lawyers, could be anybody, estate agents, could be all sorts of routes in. But we felt you had to then say from that, well, there is a problem. The fact that it cannot be absolutely quantified in very precise terms is not the point. There is a consensus that there's a big problem there. And when you overlaid on that the fact that it's fair to say internationally, London is probably viewed as one of the more permeable financial centers in the world. In other words, some of the others say actually they think it's rather easier to bring funds into London. So all of that meant that there was an issue to address, even though you couldn't produce absolutely sort of hard evidence of what it was. And the reason that was important was because the public believed that. And we'll come to this in a minute, I think. The key to all of this is the profession needs to maintain public confidence and trust. If the public think there's a problem, there is a problem anyway. Even if you can say to them, no, you've got it all wrong. Actually, you can't say to them they've got it all wrong. There is a flow of funds. So that's rather a long way of giving the answer. Well, no one can quantify it exactly, but it is a significant problem.
And you mentioned the public there, Guy, and that links in very much with reputational considerations and how the public perceives the profession. And the report actually says that when taking on a new client mandate, not only should a law firm be able to defend that decision at a tribunal, but it should be able to defend that decision within the public. Why is that so important? And what does it say about the importance of public perception in regards to not just law firms themselves, but the wider profession as a whole?
I mean, there are two answers to that. Actually, the simplest answer is that at the heart of the regulatory principles which govern the solicitor's profession, which have been there for years, there is an obligation to maintain public trust and confidence in the legal system and in lawyers. Simple as that. And actually, it is, you have to admit, yes, it's quite difficult to say exactly how do you measure that, how do you implement that, how do you determine when that confidence has been lost. But that's actually at the heart of the regulatory principles as they have always been. And you sense that, that's probably been overlooked somewhat in, frankly, for a few decades now as law firms have become bigger businesses. The other reason is all wrapped up in the broader issue of acting in the public interest, which is, in fact, that in turn is the sort of governing principle which governs what regulators should do. They're meant to be there to actually regulate in the public interest. Now, you would say, and you would have to admit that those are quite difficult concepts. Stephen Mason's done a very good paper on the public interest, and it's well worth everybody reading it, but it's 70 pages long. And that tells you that this is not straightforward. But I think the profession have sort of taken the view that tells you, all right, it's very complicated, I'll get somebody else to read it and advise me. That actually is the wrong approach, because there is a direct requirement to maintain public trust and confidence. And this particular issue, I think, showed that the public, in fact, I think, believed that it was rather easier for clients with funds of dubious provenance to actually move through the system than it actually is. But if the public believe that, then you've got a problem and you need to address it.
And I think that you've proposed a way in this report to address this from the lawyer's end and what they can do to make sure that they're living up to the level of transparency, accessibility and accountability that the public expects of such a high caliber profession. I'm wondering how this would actually work in practice, the steps.
Well, now that is also, as they say, a good question. In fact, a number of the large firms will probably say to you, well, we do something pretty close to this already. And a number of them do. But there are really two aspects to this. There is the gating process that we've set out. And it's got a sort of we think it's a slightly new bit in the middle when we talk about the legitimate provenance of wealth test. But that's very specific. So a new client comes in through the door and you actually put them through this test, and that's fine. People can read that and understand it. The more difficult bit relates to public trust and confidence generally, because what we found was when we spoke to law firms, and we spoke to quite a number, and many of them had good, sound practices, but when it came to reputation, they were almost totally talking about their own reputation. So the reputation of ABC firm. Well, that's fine, but whilst they were all very proud of their own reputation, their reputation was not actually much distinct from many of the other firms who, DEF, who had rather similar things to say about their integrity, efficiency, reliability, ingenuity, and so on. When you go back to the regulatory principle, it's saying it's the reputation of the profession as a whole. Now, if I go out to the public and say, what do you think of the reputation of XYZ firm? They'll say, I've got absolutely no idea. I could never afford to use them anyway, so how would I know? If I say to them, what's your view of the reputation of the legal profession, the solicitor's profession generally, I think they probably have quite a lot to say. Now, the duty of the firms is to look at the reputation of the profession generally. So one of the broader things we're probably saying, look, the bit about client acceptance is I think, the easy bit, because there's a test there and you apply it. And so we'll talk in a second about legitimate provenance of wealth, which is slightly additional and different. But this point about the reputation of the profession as a whole is much more challenging. And so what we've said is that we think there need to be a series of forum where large law firms meet and say, well, look, actually, how do we all approach this issue? How do we regain public trust and confidence? What are the things we have to do? Do we have to? And then they may say, gosh, actually, we haven't told the public what our tests are for taking on new clients. And then 3 minutes later, they might say, actually, I'm not sure we've even told all of our staff. Now, there is a significant challenge with transparency here. The legal profession is privately owned by and large. There's some listed entities, but very, very few. There's some private equity money, but not a lot. Generally speaking, it's privately owned, and people have presumed from that the whole thing is their private affair. But it isn't, because when you look at the barriers to entry to other people come into the profession, which are really, how do you get the various titles of solicitor or legal executive or whatever it may be within the profession? You actually have to have those. That's a barrier to entry. When you look at reserved activities, which is a list of things that only solicitors can do, including conducting litigation, that's a barrier to entry. That's an economic privilege. That's how you make money. Now, big firms would say, I mean, somebody like me, I actually went my whole career probably with hardly ever doing anything which was technically a reserved activity. But my firm prospered greatly because there were quite a lot of people who did reserved activities, and other people couldn't compete with that unless they were law firms. So back to the point here, you, the profession, have been given all these privileges and economic advantages. Did you think you were given them just because you were jolly clever or merited them or whatever? No, it was a sort of deal with the public. This is why public trust and confidence is at the heart of it. The public was saying, we expect you to exercise these properly and in the public interest. So there's a sort of deal there, which I think we're just pointing out needs to be thought through again and really needs to be readdressed. And the profession, therefore, has, which is why the Institute of Business Ethics are interested in it, because they're saying they're very happy to run a forum for the leadership. When you talk about training, everybody says, yeah, it's great, we'll send all our youngsters to train. No, we need to send, I'm afraid, all the senior leaders to train, because grappling with these problems of what is the public interest, how do you get public trust and confidence, those are the issues where a more sophisticated form of it isn't really training, but it's a forum where people exchange ideas, develop them, and then can communicate those to the public. So that was a slightly longer answer, I think, than you wanted to that question.
It's really interesting, Guy, this area of law firms, as you said, are very concerned about their own reputations, but there's a bigger job to be done the profession as a whole. And I'm intrigued to know whose responsibility is that. Is it the regulatory bodies? Is it the Law Society? Is it the Legal Services Board, or is it individual law firms? Because it's not. Many law firms would say, and including the bigger ones, would say that actually they are quite transparent and they do communicate quite openly about the kinds of clients they will work with. Do you not?
But how many of them have communicated their policies and processes for taking on new clients? I think the answer, I'm holding up one hand here with my fingers outstretched. I don't think I'd use them all. No, so in fact, there is, and if you were, for example, how would you assess, compared to the rest of British industry, the speak up culture within large law firms? It probably wouldn't fare too well by comparison with many other sectors of business. So, the level of transparency doesn't really match what the public now expect generally. And all they'll be saying is, well, look, we see these standards elsewhere. We don't accept that legal practices are different. Yes, there's client commercial confidentiality, but in fact, most of the things we're talking about are nothing to do with that. We're talking about your policies and practices. So, there is I think, a need for firms to actually be more open and then to work out how do they communicate better what standards they are applying. And that really isn't individual firms saying, we're wonderful because we do this. That needs to be the profession as a whole. But your question as to whose responsibility, it is the firms themselves. I think to say that regulators should somehow do this is quite misconceived for several reasons. First of all, the judgment about what's in the public interest, you need to, your starting point, very simple, is, well, there is no single public interest because, you may say that, oh, I'm going to act for this kleptocrat on enforcing their property rights against somebody. And so the public interest may say, well, I don't want you to enable kleptocrats to strengthen their ill-gotten gains. Somebody else may say, actually, there's a perfectly sound argument which says that it's in the public interest to have a working civil litigation system where everybody is represented. Now, which of those two is going to prevail? A regulator isn't going to tell you. You've actually got to work out what do you think, where's the public interest and how will the public perceive it. So if you leave those things to regulators, you will get more laws and regulations. But we're saying these are matters of judgment. And the other thing about the public interest is it changes. The public interest 10 years ago would have led you to views in relation to something like climate change, for example, which were entirely different from the public interest now. So these are things which require judgment, which must be constantly calibrated and constantly exercised. To suggest that a regulator should be able to tell you how to navigate these ethical dilemmas, I think it's wrong for a start. But secondly, if you actually say, I want regulators to deal, you will find yourself tied up in red tape, which won't work. And if you look at some of the recent regulatory cases on money laundering, they will tell you that no laws were broken, but that people exercised appalling judgment. Not all of them will say that, but you will find that. So that the regulator can really only say, I've got these rules and I'll apply them stringently, but those rules simply will not be able to answer the question, what is in the public interest here? And the only people who can do that are legal professionals. The public will tolerate them doing that if they see them doing it, in their view, ethically and properly. And that's what they've got to be seen doing now.
And I think there's maybe a question there of if law firms, they do take on exactly what you're saying there, and they maybe swing too far to the other side, and they're perhaps scared to take on any client that's even remotely akin to someone that's a bit dubious, what happens then?
Well, a thinking, sentient profession would then be reevaluating the public interest and would be saying, well, hang on a second, we've got an access to justice deficit here now. That needs to be addressed. But I mean, I would temper those remarks simply by saying, if you survey the SMEs of England and Wales, and I'm involved in a number of SMEs, they would probably say the law isn't for us, we can't really access it, we can't afford it. So they're not getting, so before getting over bothered about the public interest of kleptocrats not being able to get representation, I think there are quite a few other categories, including most individual citizens can't afford it either. We might be better off just applying our brain power to solving those problems, I think. But it's not, but it's a perfectly proper question. And the answer lies in the public interest. Because if you're saying, no, actually everybody's running scared, and they're not acting for foreigners, let's say. Well, of course, that would be deeply against the public interest because we've got an open mercantile economy, which depends on international trade and international finance. So you would say, well, hang on, that isn't the public interest at all. And you would have to adjust what you were doing. So that's how I think the process would play out.
I asked the question because I'm thinking of the greenwashing, that's happening in ESG with companies who have went, they went one way and, we're so green, and now they're so afraid to say anything about their sort of eco drive. So that's kind of where I was thinking about it there. But I think Gus, over to you here about public companies and law firms.
Yeah, Olivia, I want to come back actually to Guy's point about sort of public perception and public scrutiny, and that it's true, isn't it, that certainly law firms are much more in the spotlight and scrutinized by the public for all kinds of reasons. I mean, more and more law firms are now announcing their financial results. There's more scrutiny on, what is a 50 billion UK industry in the UK alone. The media is more and more interested in law firms, and so a lot of that accountability comes from the sort of spotlight that's increasingly shone on law firms, and certainly law firms, as you said, Guy, are much more worried about their public reputation and their reputation as law firms, and with responsibilities to a number of stakeholders who do care about the kinds of clients they take on, including, the young generation of lawyers who will be the partners of tomorrow. Is that not having a positive impact, albeit law firms are sort of sometimes taking a forced approach to some of this, you could argue, but that must be having a positive impact as well?
It would do, although you would have to say that if you set law firm governance against public company governance, there would be a bit of a deficit on the law firm side in terms of independent thought and checks and balances, which, so I think there's a long way to go there. But your question about, what are the drivers for change is an interesting one, because we met some criticism from people saying, no, this should be greater regulatory intervention. Otherwise, why will people change? And our answer to them was, actually, if you take a professional services firm, the one thing which causes it to change course very quickly is if it can't recruit the next generation of people and of what it sees as the best people. That is the one thing. Now, that doesn't sound a great answer to some outsiders who say, no, we don't believe that everybody's motivated just by money and greed. And you'd have to say, well, if you want to look at it in those terms, well, this is money and greed, because the law firm model relies on having this sort of pyramid of people. Well, there is no economic success if you're not able to do that. And if you haven't got access to what you view as the best people, your performance will suffer over time. So you're absolutely right. That is a driver, but what we're saying is one of the most important bits of transparency for firms is with their own people, so that they know exactly what the processes are. That will not always be the case at the moment. Now, there has to be, if you didn't then address dealing with more public stakeholders, they probably would say, well, we don't believe you, or who knows whether that works. So you have to do both. But I would say for those, and there are a number who say, look, the only answer to this is more laws and greater regulatory intervention, I would say no. And I would actually also say, look at some of the enforcement cases of recent years, which and the money laundering laws and the sort of related sort of unexplained wealth order and other legislation and regulations are very good, and they're very necessary. But being laws, they have to be enforced fairly and strictly in accordance with their terms. So you will read, for example, in one of the recent cases where there was a long debate between two distinguished KCs about the difference between adequate due diligence and reasonable due diligence. Now, you and I can recognize there might be a difference, but I wouldn't expect anybody else, frankly, to think that's a particularly sensible way in which to determine whether an outcome is essentially in the public interest or not. And so the reason you get that is because if you really have what we would call justiciable tests, in other words, your tests are ones which are going to be determined by the court, ultimately, if you go that far, or the regulator. And in the middle of our gating process for taking on new clients, we've said, well, look, there is one step which that simply requires you, the firm, to be satisfied that you positively are happy that you know the origin of the client's wealth and you know it's of legitimate provenance. Now, then some said to us, well, yeah, but I mean, what happens when it goes to court? So no, that's nothing to do with the court. That's actually, you've got to be able to stand up in public and people say, well, you've got to be joking, because you will have seen, for example, there was a case, it's in a different context, it's in SLAP's context, which is different, dealing with Prigozhin, which was suggesting that, rather hard to tell whether he really was a villain or not, but that slightly pejorative way of putting it. But most of the public saying you've got to be joking. Surely it's obvious. Now, actually, then you go back to some of these other cases and they say, well, where's your evidence? You're then back to the problem of state capture. Say, well, we couldn't get an evidence. Have they ever been convicted of a criminal offence? Well, no, because they're on the home team. They're in the ruling elite. And so the justiciable tests, the legal tests, are fine. You actually have to have them. But we're saying there's got to be, if you like, a sort of top hat on that, which in very crude parlance is saying, look, is it lawful? But it's actually awful, because if it is, you should not do it. But no court can come and say it wasn't lawful, but you should expect the public to say you have actually fallen below the standards we expect. And if the public start to lose confidence in the profession, well, then we're back to where we started. That will quickly unravel.
You've been listening to Counsel Culture, the Business of Law podcast brought to you by Byfield. Thanks for listening. Don't forget to subscribe and join us again next week, where we'll be discussing some more of the biggest stories in the legal sector.